Hello, landlords and fellow professional property managers. It's Tony Klein with HomeVault Property Management. I'm back with another legislative update for the state of Colorado. So I've got a bill in my hand, and I'm going to use my notes because there's so much in here that we need to go through that I want to make sure that I don't miss anything. So this is, again, House Bill 20-1141. It's a bill concerning restrictions on the fees charged by landlords. So this is going to cover a whole bunch of fees. So this bill is going to prohibit the landlord, and it says a landlord of a mobile home park or a residential premises. I'm going to focus on the residential premises, even though these are going to apply to the owners of a mobile home in a mobile home park. So this bill prohibits a landlord of a mobile home park or a residential premises from charging the tenant a late fee for the payment of rent unless the rent payment is late by at least 14 calendar days. So what that means is, in the past, I know a lot of landlords are using the rent to pay the mortgage. Not everybody has 6 months worth of income sitting in a bank account just in case the tenant doesn't honor their commitments under the terms of the lease. And so I know that cash flow is very important. But under this new proposed law, you would not be able to charge a late fee to any tenant unless the tenant is 14 days past due with the rent. Now, we all know that last year there's a couple of bills that were put into place. I'll get to one of them in a minute. But one of them was that we changed the 3-day notice to pay or quit, so a 3-day lease violation notification, to a 10-day. So we're already extending the notice to 10 days. Now we're extending the ability to charge a late fee to 14 days. So that's item or issue number one. The second issue, or the next issue, is charging a tenant a late fee in the amount that exceeds the greater of, now get this, $20. So if you do wait 14 days, you're going to be able to charge a late fee of $20 or 3% of the tenant's monthly rent obligation. So that means if your rent is over $667, you're going to be capped at a late fee of $20. So if you do decide to charge that, you're only going to be able to max out at $20, and that's after 14 days. The next thing is we're not going to be able to remove or initiate eviction proceedings, so remove a tenant or initiate eviction proceedings against a tenant solely as the result of the tenant's failure to pay late fees. And that'll come into play a little bit further down here. We'll not be able to impose a late fee on the tenant for late payment or non-payment of any portion of the rent for which a rent subsidy provider rather than the tenant is responsible for paying. So here's another law that was put into place recently. Source of income is now a protected class in the city and county of Denver. And so what you'll be watching is you'll watch that kind of roll throughout the state. But what is important here is, number one, we can't charge a late fee unless it's 14 days late. Number two, we can't charge a late fee on anything that is provided by the housing provider or Section 8 or one of these additional housing subsidy providers. And so what happens is, if they have an issue on their side, well, it's not really the tenant's fault, so you're not going to be able to charge a late fee, even though it's not the landlord's fault either. So source of income is now required. You have to sign their addendum, their paperwork, and you have to just deal with it if the rent or the subsidy part is late. Next issue is imposing a late fee more than once for each late payment. So if their rent payment, late fee payment rolled over to the next month, you wouldn't be able to charge any sort of late fee or any interest. You wouldn't be able to charge any interest on that either. And then to carry on, so a landlord shall not require a tenant or mobile home owner to pay any fee or charge other than rent, okay, except that the landlord may require a tenant or mobile home user or owner to pay a use-based fee that is described in the rental agreement. So what this is saying is, not only are we dealing with late fees, but we're dealing with all fees. So you can charge your tenant rent. That's it, with one exception. You're now going to be able to charge what they call a use-based fee. The use-based fee is for a utility or an item in a common area of a residential property that the tenant is using, and it has to be based on their use, and we'll get into that in a little bit. So if a landlord provides to a tenant or mobile home owner a utility service that is not individually metered, the landlord shall include the cost of the utility service in the tenant's rent and charge the actual cost of the utility service on a uniform basis to all tenants or mobile home users who receive this service. Okay. I've already covered the rent subsidy provider, so that just means any public or private entity, including a public housing authority, that provides financial assistance to a tenant or landlord for the purpose of subsidizing rent. So if they fail to honor their obligations or the terms of their lease agreement, it really falls back on you. There's really not anything you can do about it as a landlord or property manager. Again, the use-based fee, we're going to cover the definition of that. So the use-based fee means a fee that the landlord requires a tenant or homeowner, a mobile home homeowner, to pay in exchange for the use of a service or a facility that is located in the common areas of a residential premises. And the amount of which is based on the amount of the tenant's use of the service or facility. So for example, if you decided you wanted to start charging the tenants for the HOA fees, you're going to have a hard time justifying that because you have to charge it based on their actual percentage of use. So a fee is not a use-based fee if a landlord requires a tenant to pay the fee regardless of whether the tenant uses the service or facility that is associated with the fee, or different tenants are assessed the fee in the same amount despite using the service or facility that is associated with the fee in different frequencies, amounts, or levels. A lot of pages on this bill. So a landlord shall not terminate a tenancy or other estate at will or a lease in a mobile home park because the homeowner or tenant fails to pay one or more late fees to the landlord. So not only can you not collect more than $20, but if they fail to pay on time and they fail to pay month after month, and you decide that you don't want to renew, you're not going to be able to terminate that tenancy simply because they do get caught up on the rent, but they don't pay the late fee and continue to pay late. The landlord cannot require a tenant or who owes one or more late fees to the landlord to pay any amount of interest on the late fees, or recoup any amount of late fee from a rent payment made to the landlord by the tenant or homeowner. And typically what happens in general accounting is when you receive funds, you apply those to the oldest debt or the oldest outstanding fee. That's no longer going to be the case. We're no longer going to be able to do that. And then here's a kicker. So a tenant has a private civil right of action against a landlord who violates this section. In such action, the tenant or homeowner, again mobile homeowner, is entitled to 3 times the amount by which the imposed late fee exceeds the allowable amount of the late fee, if any, as well as actual economic damages and reasonable attorney's fees and costs if the tenant prevails. If a landlord is found to have imposed a late fee in bad faith, the tenant or homeowner is entitled to damages in an amount not less than $2,000. So if you charge a late fee and they determine that it's in bad faith, and again that's at the sole judgment of the presiding judge, your out of pocket is going to be not less than $2,000. In addition to that, the Attorney General or Department of Local Affairs may file an action on behalf of a tenant or homeowner against a landlord who violates this section. So even if the tenant decides that they're probably in the wrong, the Attorney General or Department of Local Affairs can pick up their case and carry it forward. And again, that doesn't cost them anything. It just costs you as a landlord or as a property manager. So fees prohibited generally, so use-based fees are permitted. A landlord shall not require a tenant or homeowner to pay any fee other than fee or other charge other than rent as set forth in the rental agreement, except that the landlord may require a tenant to pay a use-based fee that we've already talked about. They're also saying that the utility cost should be included in the rent. If the landlord provides to a tenant utility service that's not individually metered, the landlord shall include the cost of the utility service in the tenant's rent and charge the actual cost of the utility service on a uniform basis to all tenants or homeowners who receive that service. Next couple of sections here are just kind of clarifying some things. But then the very last section, section 10, it's their safety clause. And it says, the General Assembly hereby finds, determines, and declares that this act is necessary for the immediate preservation of public peace, health, or safety. So they've determined that in order to protect the public, and I guess they're splitting hairs on what the public is, because in my mind a landlord is just as part of the public as a tenant. But in order to protect the tenant or to protect the public, they're going to immediately change everything that I've just read and try to enforce that. So it's a bill, it's not a law yet, but it's coming. Again, it's House Bill 20-1141. It's got House sponsorship and Senate sponsorship, and it's going to be coming up to the floor for a vote or to be heard very soon. So I would recommend that you get involved. If you've watched this video, I will put some comments down below where you can reach out to your representatives. Let's try to get this corrected so that I agree with having a balanced system, but this throws it way out of balance in favor of the tenant. So anyway, I'm Tony Klein with HomeVault Property Management. I hope you've at least been informed on this legislative update if you haven't enjoyed it. Thanks.